Hello friends, how are you all? So today we are going to discuss Article 21A of our Indian Constitution in this video, and in the next video that I am going to make today will be about Article 22. So let's start with today's lecture. So it is lecture 14 of our series. I hope you are watching the previous lectures also. Kindly watch them. So this Article 21A is about right to education. It grants right to education to all children between the age of 6 to 14 years. Okay, this is about elementary education. Okay, so what is the background of this? Initially, when the constitution was adopted, there was no Article 21A. Okay, for various reasons, it was thought that granting education as a fundamental right will be can be a problematic thing, because fundamental rights are guaranteed rights, and considering the literacy level of the country at that time when India became independent, and the vastness of population of our country, like these were the conditions which restricted constitutional makers from adopting right to education, right to elementary education as a part of fundamental rights. So instead of providing right to education as a fundamental right, what our constitutional makers did was they adopted Article 45. What is Article 45? It falls under the category of directive principles of state policies. So what are DPSPs? DPSPs are not like fundamental rights. They are not guaranteed or they are not enforceable. Instead, DPSPs are a guiding line, a guiding light for the state. It DPSP provides guidance to the state as to in which direction their policies should lead to. So under Article 45, it was provided that the state will endeavor to provide education to all children between the age of 6 to 14 years. Okay, so it was left to the state, and there was one more condition. When the constitution was adopted and Article 45 was provided, a limited period was provided that the state has to provide this right of this availability of education to the children within 10 years of adoption of this constitution. So this requirement of 10 years was provided there, but because of various reasons, this could not have been done. So instead, even after 40, 50 years after the adoption of the constitution, this aim of the constitution makers could not be achieved. So there was various issues. Okay, so a question arose. See, this was DPSP, a specific right to education. But when we did our last lecture about Article 21, we get to know that there were various different elements of a human existence which are held to be covered under the purview of the words life and personal liberty that are used in Article 21. So as we discussed in our last lecture also, this education part was also held to be a part of basic necessity of any human being, and hence a part of right to life and personal liberty, and hence falling under Article 21. So by way of interpretation, the Supreme Court held that right to education is a fundamental right of. So what was the case? If you remember, if you have seen my last lecture, it was Mohini Jain versus State of Karnataka. This was 90 case of 1992. In this case, the Supreme Court had clearly held that right to elementary education, education for kids between the age of 6 to 14 years, is a part of is falling within the purview of Article 21, and hence it is an absolute fundamental right of all citizens. Okay, the next case which was decided on similar lines as Mohini Jain was Unni Krishna versus State of Andhra Pradesh. This was a case of 1993. In this case also, right to education was held to be falling under the purview of Article 21 of the Indian Constitution. So what happened? Okay, so the question arises, if in the cases of Mohini Jain and Anmi Krishna, right to education or right to elementary education per se was held to be part of Article 21 and hence amounting to fundamental rights within Part 3 of the Constitution, then why was there is a need to adopt Article 21A? What was the need of it? So the answer to this would be that what was done was a judicial interpretation. Okay, and as we know that the precedents, though they are bound, though they are binding on all the legal strata of our society or our state, but precedents are not permanent in nature. They can be uh, like set aside in future cases by the Supreme Court itself, okay, or by an act of parliament. So to avoid that thing, it was thought by the parliament that it will be better to provide a specific and separate article, making Article 21A and providing for a separate provision as a fundamental right for elementary education of children between the age of 6 to 14 years. So these were the consideration to provide clarity in the law, to provide permanency to the provision. So for these consideration in mind, 86th Constitutional Amendment Act was adopted in the year 2002. So by way of 86th Constitutional Amendment Act came into existence Article 21A. What does Article 21 say is that the state shall provide, mind the words, free, okay, free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. Okay, so what are the things that we need to remember in this section, in this article? The first thing is that it is the duty of the state. The state shall, the state would be bound to provide it. So what it means is that the state does not have the discretion to either provide it or not to provide it. Instead, the state is bound to do it. The word shall is used. Second, that the state cannot charge any money for that thing. Okay, the state cannot provide for a monetary provision in that. So the education that the state is providing as a fundamental right has to be free. Okay, it has to be free. And the third important point is it has to be free and it has to be compulsory also. So the state will make provision in such a way that it will bind not only the state but also the parents or also the educational institutions to in a way force and coerce them to bring the students to the educational institution, so that they can have benefit of this provision. So the first thing is the state is bound by it. Second, the education shall be free, and third, it will be compulsory, okay, to all the children of the age of. Fourth important thing is this fundamental right is applicable to what category of children? All the children who are between the age of 6 to 14 years. Okay, this is the fourth condition. And after this, providing for this free and compulsory for the kids of 6 to 14 years, it has been left to the state that how it is going to do that. So in this way, a bit of liberty is provided to the state to decide how they are going to ensure a free and compulsory education to children between the age of 6 to 14 years, as in such manner as the state may by law determine. Okay, so uh, the only restriction that has been placed on the discretion of the state in the manner of providing is that it has to do by way of law. What it means is that a state has to adopt an act, a legal act, by following all the procedures provided by the parliament committee and all, that it has to provide for an act by which through which it will provide free and compulsory education. So what are the points that we need to remember? That the state shall, it will be free, it will be compulsory for the children between 16 to 14 years, and by law. These are the 5 conditions of this Article 21A. Write them down. Okay, so after the adoption of Article 21A, the Right to Education Act was passed by the Parliament in pursuance of this bylaw requirement. Okay, so this Right to Education Act of 2009 provided that all educational institutions, whether they are public, whether they are private, whether they are aided or unaided, whether they are minority or whether they are normal education institutions. The provisions of Right to Education Act will be applicable to all equally, and they all will be bound to provide to preserve at least 25% of the seats for educationally poor kids between the age of 6 to 14 years. So, in order to challenge this provisions of Right to Education Act 2009, the first case that was brought on record was Society for Unaided. See the words. You will know the whole story by the title only. Society for Unaided Private Schools, Rajasthan versus Union of India. This was a case of 2012. In this case, what the what happened that all the unaided private schools of the state of Rajasthan, they came together and filed this case before the Supreme Court. And by way of their petition, what they said was that it is the state who has the responsibility under Article 21A to provide education, and the state cannot force the private parties who are in not in any way being paid by the state or supported in any other manner by the state to provide to reserve seats for poor or educational institutions or give preference to them in any manner. So what the essential contention was that the private participants of the market of the education sector can't be forced, can't be imposed. These provisions can't be imposed on them because they are not being aided by the state. They are not state education institutions. They are the private. And what are the motives of the private? They have their main motive is to make profit. So this was the whole background of the case. So in this case, the Supreme Court again reiterated that it is not only the responsibility of the central government to ensure that the literacy level of the country is like increased, and to ensure a good education and a decent life for the future generation of our country. And if a particular person is entering into such a occupation or business such as education institution which serves which performs such an essential function towards the society, he cannot contend that he should be left free to conduct his business the way he wants. Okay, so this argument of being free on based on Article 19(1)(g), as we discussed 2 lectures back, was rejected by the Supreme Court. That by holding that education sector cannot be put at par with other economic activities. And the other thing was the Supreme Court held that it is not just the central government who can like who is under the responsibility to provide. If the state considers that it is necessary to include the private players also to make the law more comprehensive, the reason being that private public education institutions are very limited, so it will never be that effective if it is being restricted to public. What will happen that all the public institution will be flooded with applications, and public institutions, schools do not have that much capacity in the present times. So it is very necessary that private members, participants, private schools are also included within its purview so as to give it a broad power, broad purview, so as to be more comprehensive. But the only exception that the Supreme Court accepted in this case was that it was wrong to include unaided minority schools. Okay, so the thing was, Even I did not understand why Supreme Court had it. So if it wanted to exclude minority schools, so it could have excluded them completely, whether aided or unaided. But in this case of Society for Unaided Private Schools, the Supreme Court only provided an exception only in favor of unaided minority schools. What are these minority schools? Under Article 29 and 30 of our Indian Constitution, certain rights have been provided. Certain rights have been provided to minority communities based linguistic on linguistic grounds. Okay, so they have certain rights to establish and administer educational institutions and all. So in order to protect their rights, these powers have been given to them. So considering certain facts, in this case, unaided minority education institutions were excluded from the purview of Right to Education Act 2009. So the next important case that came into light was Pramati Educational and Cultural Trust versus Union of India. This was a case of 2014. Okay, what was the same arguments were repeated again. Okay, nothing different. But the only one thing that came into purview was that in the first case, it was Article 19(1)(g) argument. Okay, that was being reiterated again and again, that we have a free hand to conduct our occupation and all. But in this case, it was Article 15, sub Article 5 also that was challenged. What does Article 15, sub Article 5, that as we discussed earlier, provide that by through that article, I guess it came by 93rd Constitutional Amendment Act. It provided that even unaided educational institutions are also bound to provide reservation, follow the reservation policies of the state, and provide reservation in favor of scheduled castes and scheduled tribes. Okay, so but in Article 15(5), there is no mention of minority education institutions. So minority education institution has been accepted under Article 15(5). So the question arose whether by same considerations, uh, can it be held that from Right to Education Act also, these minority education institutions should be removed, for the reason that if such a policy is imposed on them, the essential nature of these institutions being of minority or promoting their language or culture may be threatened. So considering all these considerations, and by looking at Article 15 sub-article 5 also, in this case the Supreme Court held that minority schools in toto are excluded from Right to Education Act 2009. See the difference. In the first case, it was only unaided minority education schools that were excluded, but in the second case, it was minority schools in total that were whether aided or unaided. They were completely excluded for the reason that because of this imposition of regulations of RTE, what will happen is they may lose their minority character. But the question that still remains is, see, these minority schools have been provided like quite full, like a free hand, complete free hand. So what level of education they are providing, and what are the things that are being taught in the name of promotion of language and culture? So this is a thing that needs the attention of Parliament. I hope that something comes up in future very soon. Okay, so this was our article 21. So I'm going to close this video for now, and I will make another video on article 22. Okay, so see you in the next video.